Northwest Liberty News.
Al, opposition to the CSKT Water Compact has been a central theme in your campaign. Some of your opponents claim that continued opposition to the compact could result in a long, protracted court battle, which would cost millions of dollars. If you can, Al, take a minute to educate those who may not be aware how, really, when it came down to the vote, the rules seemed to be changed when it came to the compact. And if I'm recollecting correctly, I believe the Montana Constitution was violated in some sense for that compact to get as far as it is now. And as a follow-up, can you let my audience know what steps you would take as a U.S. Senator to ensure fair and proper negotiations surrounding the CSKT compact?
Sure, Jim. Just to educate everybody out there, as a candidate for the United States or the United States Senate, is that I truly believe that in order to take back the seat of the U.S. Senate from the National Democratic Party, which is held currently by John Tester, the way the Republican Party and our conservative movement here in Montana does that is fighting for issues that cross party lines. And I do believe that the Salish-Kootenai Water Compact is one of those issues that crosses party lines because deep down in the hearts of Montanans, our property rights, especially water rights, it just rings true that we need to defend that regardless of whether or not you're Republican, Democrat, Libertarian, or Green Party, or you're an independent. It just rings true. So what we have in a heartbeat is that all the tribes in Montana have a compact. It carries the weight of a treaty. It quantifies the amount of water or water rights that all the tribes have in Montana. But there's one tribe that doesn't have a water compact, and that's the Salish-Kootenai Water Compact. But for the other tribes, we created a water compact. It was created as a negotiations between the tribes and the state of Montana, and then ratified by the Senate up in the United States Senate. And all the compacts for all the other tribes were bipartisan and were near unanimous in vote, and they were passed. But not so for the Salish-Kootenai tribe. The Salish-Kootenai tribe is a tribe of 5,000 members, plus or minus, and they created a water compact with Governor Schweitzer and Governor Bullock behind closed doors. I'd like to tell people Western Montana was not at the table to work with the tribe and the government. We were on the table. And what was created was a water compact that gave the tribe, a third party, the water rights to all of Western Montana. In essence, they created a new precedent called Aboriginal water rights. Now, Aboriginal water rights grants the Salish-Kootenai tribe the water rights to their nomadic range of the Columbia River drainage in Western Montana. This is a precedent never before seen in water court or determining water rights. In fact, it's given a timestamp for those that understand water rights. You have a timestamp of where your water rights are based on the time you receive them. And it receives this timestamp called time immemorial. So even if you're a Montanan or somebody that has a rancher that has territorial water rights from all the way back in the mid 1800s, this would then allow the tribe to become a senior water right holder to you. It also allows the tribe to have the water rights without showing beneficial use, which is another precedent that's never been seen before in water court. So what it has happened is a tribe, a third party of 5,000 people, have 27 million acre feet of water per year. That's more water than you'll find in Flathead Lake and Hungry Horse Reservoir combined. And that water, they don't have to show a beneficial use at it. And here's the thing, if you want to put it in proportion, it is four times more water than all the tribes in the United States, including Alaska, put together. 27 million acre feet. That is unbelievable. But here's the kicker, is that this was put together and it was brought to the House or to the state legislature in 2013, and it failed. In 2015, it was passed, and it was passed only because the rules of the House were thrown out by the Democrats with a few responsible Republicans who threw out the House rules, and they turned the House of Representatives in Montana to the rule of the jungle. And by doing so, they threw out the Montana Constitution, which requires that you have a supermajority, or 61% of the House and the Senate had to vote for this compact in approval in order to get it to be a legitimate passing. But because the rules of the House were thrown out, they basically threw out I would say that the way it's looked at is they threw out the Montana Constitution, and that's how they were able to push this water compact through the state legislature. Now, here's the issue. The issue now is at the state or the U.S. Senate level. It needs to be ratified by the Senate. It needs to be, money is appropriated by the House to go with this compact. John Tester has wrapped this up in $2.3 billion from the federal government to go to this party of 5,000 members. And the state is obligated with our taxpayer money to give $55 million to this third party of 5,000 people. And the only place to fight for this right now is at the Senate. We have to stop this compact at the Senate so it's not ratified and passed by the Senate. This is something that John Tester clearly stands for. I am clearly against it. I have my contenders in the primary. I'll tell you, Matt Rosendale says that he opposed it when he was fighting as majority leader in the state Senate in 2015, but he doesn't really tell you where he stands right now because he would really not like to try to anger the beast, as so we say, the third parties that want to see this Aboriginal water right. My contender, Judge Fagg, he 100% supports the water compact as it's written, and said it's the best deal we could get. It could be worse if we go to court and we have to fight for our water rights. And as I tell him, I guess I'll get back to that. Troy Downing, he just doesn't understand it. He hasn't been in Montana long enough to understand the importance of what these water rights are and why we fight for them. So going back to Judge Fagg, I've said, look, and we've been in debates, and he says, look, this is the best deal we can do. I support it. We need to pass it. And I tell him, I said, Judge, in Western Montana, again, we were not at the table, we were on the table. And we want our day in court. We want our due process. If we lose a property right through due process, I may not be happy, but I'll respect the process. But the fact that through legislation that was done unconstitutionally and by throwing out the rules of the House, what we have is a taking of private property that is done in a way that is theft or plunder by our government from the Western Montana and given to a third party. And that cannot happen. I won't stand for it. And here's the part that I tell people in Eastern Montana, is that if a precedent of Aboriginal water rights is actually established, that means that the Crow tribe can then demand this new precedent. And they'll want Aboriginal water rights to the Yellowstone and its drainage. And the Blackfoot tribe will want their Aboriginal water rights to the Missouri River and its drainages. If that is allowed to happen, if the precedent is set, they will be able to get it. Then we will have to go to where? To our Montana Constitution, and we'll just have to rip out the pages that say that the water belongs to the people of Montana for our common enjoyment. Because the people of Montana will no longer own the water in common here in Montana. We'll throw those pages away because we'll have to buy the water from a third party that owns all the water in Montana. This has to be stopped in the Senate. The state of Montana has to create a new water compact that solves this issue, but does in a compact that's no different than the rest of the tribes here in Montana.